the law, and it would help if I didn't run up and down the stairs before I started. In fact, well, it is just a little bit longer because the 51 years in the law, well, the inception was in 1964 when I was still at school. I was doing O levels, and I made a decision. I remember exactly where I was. I went to Hasmonean. I was in the front playground, and I decided that I wanted to be a solicitor. And I went home and I said to my father, who was determined that I become an accountant, and I said to my father, "I'm very sorry, I don't want to be an accountant." And his face fell. But the next sentence was, "I want to be a solicitor." And his face was up again. I got the necessary A levels to go into law, and then had to make a decision on whether to go to university for a degree or to do what was at that time possible, which was to do 5-year articles. And I remember with my father, I went to see Mr. Stanton, who was those years the very, very well-known headmaster of the Hasmonean. And he said to me, "What do you want to do? Do you want a job in a firm, or do you want your own practice?" And I said I wanted my own practice. And he said, "Well, what you need, therefore, is to have the full 5-year articles. That works as a sandwich course. And you do a period of time in law school, then a period of time in the office, and a period of time in law school, and vice versa over that period of 5 years." I then had to find what was in those days called articles, which is an apprenticeship. And it was quite common then for the firm that took you on to actually charge you. It was just beginning to change, and I had 2 offers. One from Asher Fishman, and another from a well-known Jewish practice. Both are Jewish practices. And I decided to go with a gentleman called Asher Fishman, who was the head of the London Board of Religious Education. And I was with him for 5 years. In that 5 years, I passed all of the necessary exams with a year to spare. So after 4 years, I had done everything to qualify except survive. And on the 1st of December 1971, I was admitted as a solicitor. So the 51 years starts from 1966 when I entered articles, and I retired in 2017, actually on the 1st of October 2017, which was Yom Kippur. The day I retired was when my indemnity insurance ran out. So, in the period of articles, I had done some litigation, but basically was a conveyancer and dealt with probate and wills. After serving the 5 years of articles, I then went to Mr. Fishman. I said to him, "What's my future?" And he said, "Well, stay with me for a year, and at the end of the year, I will then give you a partnership of 1/3 of the practice," which to me at that time was a good idea. But the problem was I was 23. He was nearly 60. Now, nearly 60 to me at that time was an old man. And we had nothing in common. I was ambitious. I wanted to drive ahead. He was staid. He had a good practice. He didn't want to go any further. So 6 months into the year that I was meant to stay with him, I opened my own practice. And so where was I going to open? I had no connection. You just open your door and say, "Baruch haba, ich bin du," right? I'm here. I'm a solicitor. And then things happened and opportunities arose. The first thing was that my father owned a shop in East Ham, and the upstairs of that shop was vacant. So I agreed with my father that I would pay him rent, but I also knew that if I couldn't pay the rent, I wasn't going to get chucked out. And on the 2nd of January 1974, I opened my own practice. And I just did not appreciate the lucky moment. Conveyancing is buying and selling property, acting for the parties. But until that time, one solicitor could act both for a vendor and for the buyer. You could act on both sides. In fact, where I had been articled at Asher Fishman's, we did it that way. We acted on both sides, but to maintain independence, one solicitor in the firm acted for a buyer and another one acted for the seller. But that, unless the people were related or something like that, that was impossible. It was against the regulation. So the area in which I'd opened, which is in East Ham, was dominated by two firms of solicitors, both of whom had opened before the First World War. And between the two of them, they had 95% of the conveyancing work in the whole of the London Borough of Newham cut up between them. But suddenly, they could not act on both sides of a transaction. So if they couldn't act on both sides of the transaction, you'd normally, if you had the choice, would act for the seller, because you then, when the seller sold, you would buy something else. So you had two cases. So what are they going to do? They're acting for a seller, or they have to send the buyer away. Well, they're not going to send the buyer to their opposition, their competitor, that they've been competitors since the First World War. And so here is this new fellow. And out of the blue, I had been open for maybe 3 weeks, and I was getting 10 new conveyancing cases a week. It was a rate that I couldn't cope with. And I then employed within the first month a specialist conveyancing assistant, and started to build a staff. And I then tried to use a little bit of, hopefully the Yiddish Seichel, that whenever I was acting for buyers, hardly ever a seller. And who is buying in East Ham, which is one of the cheapest areas of London? Answer is, first-time buyers, new couples. New couples, have friends. So whenever I acted on a purchase, I would just build into my fee the cost of a potted plant. And when the people moved in, they would get a potted plant from me, which was how wonderful. And they started recommending their friends. So in no time, I had a viable practice. The next thing that happened was about 18 months later, there was a mortgage freeze. There was a recession in the country, and there's a mortgage freeze. And I think, oh dear, all that I've now built, and I've now got staff, I've got expenses, how can I continue? And the answer was that the London Borough of Newham, right, and the GLC said that they were opening the market and they would give local council mortgages, but only on properties that cost less than £10,000. You think it's a long time ago. Where were properties in London that were then under £10,000? East Ham, actually in Greenwich. So when across the London, for every conveyancing solicitor was in trouble, I was getting work still. Not only was I getting work, I was getting work that was recommended by my competitors at times, and I was getting work where nobody else was, and because of the mortgage value. And all of the young ladies that I've acted for in the past were recommending their friends. So the practice continued, and the turnover of money through a solicitor's client's account is enormous. If you're buying a property for those days said £10,000, you had to receive £10,000, be it from the deposit from the client and the mortgage. And then you had to pay out £10,000. So every single case, right, there was a turnover of £20,000. And if I was on average at that time doing 8 cases a week, I was turning over £160,000. And I'd been open about a year, 18 months. I got a telephone call from the bank. The bank manager saying, would I come and see him? Okay, I'll go and see him. I know I've got no overdraft. I know he's not. What does he want? And I went to see him. He said, Michael, you have got the biggest turnover of any business in this branch in East Ham through the client's account. What type of work do you do? Well, I'm 25 years old. I've got all the confidence and arrogance of a kid, and said, I'll take, practically anything. Says, do you do criminal work? I said, well, I don't do criminal work. I've never dealt with a criminal case ever, but for decent type of work, I will do it. He said, well, I can recommend criminal work to you. I then employed somebody especially to do criminal work. And out of the blue, we're being recommended by the bank some really heavy criminals. There was a case of the daily payroll being held up by a gang with a Sten gun. And suddenly they're in my office, these people who have been arrested for it. What I found out later, that this bank manager, the bank manager to the mob. If there was a robbery today, the money was paid in cash, right, into his bank the next day. And he was recommending these people to me. Well, I frankly did not want to know that level, but I was employing somebody to deal with that type of work. That person, with that connection that he had, went off and started his own practice. But I had in the meanwhile seen that there was a reasonable level of work, and I, like most conveyancing solicitors, find conveyancing very, very boring. It's the same thing over and over and over, while litigation is interesting, be it civil litigation or criminal litigation. And the office that I had so luckily opened in East Ham, and by the way, 18 months after opening, I had moved a little way up the road and taken the whole premises. It's a much larger building. And it backed onto East Ham Police Station. Not something that I had worked out, but people were coming out of East Ham Police Station round the corner into my office. So I made a decision I was going to find out about criminal work. And I decided that I would do a duty solicitor stint at the local magistrates court to get to understand the system and how it worked. And I found it interesting. And I started to take cases. Now, I remember one particular case where it had taken 6 police officers to get somebody into the cell after having arrested him. And I walked into the police station and said, okay, let me in, let me see him. To which, full of bravado, all 5'2" of me, it had taken six policemen to get him in. And he said, you can't go in there. He's a nutcase. I said, no, you don't understand. I'm on his side. And they let me in. I spoke to him. And he was on what I now had learned the language. He was on a bender. And what is a bender? A bender is a suspended sentence for stealing something. And they had him dead to rights. I said to him, well, look, you're on a suspended sentence, which means that that will be reactivated. And I think you'll get 9 months on top. He said, no, I won't. No, no. I've got a family, etc. No, you did plead for me. So I went into court and I pleaded for him, and the magistrates gave him, as I had predicted, the 6 month suspended sentence. And following that they added 9 months as additional sentence. Now, East Ham Magistrates Court is an old-fashioned court. The magistrates are all the way up there. The defendant is in the dock behind, and you are in the well of the court. And all of a sudden, there's a great noise from behind me. This man is going bonkers, and he jumped over the dock and landed on the desk in front of me. On the right, there is a police officer who's in the witness box, who has jumped over the witness box, and he's landed on the desk in front of me. And other police officers have come from the other side of the court, and and I am sitting, and I've got hobnail boots all round me. And somebody said to me, what was it like? I said, what was it like? I understand what the ball in a rugby scrum feels like. Well, after that, from the duty solicitor case, I was asked to see somebody in a cell who was a young man. And I got into the cell, and he asked, what's this all about? He said, they've accused me of murder. I said, did you do it? No, of course I didn't do it. I don't know why they've arrested me. I made a bail application for him, which of course is always refused, and sat back. And months later, while he was in remand waiting for trial, the papers came from the prosecution. A pile of papers from the floor to here. Start going through them. And what had happened was very, very clear. And afterwards, I have to say, I went and congratulated the police officer involved. There had been a robbery in a pub. This young fellow had gone to the pub with a sawn-off shotgun. At the closing time of the pub, he went into the toilet, locked himself in the toilet, waited for the pub to empty. But what he didn't appreciate was that the pub had an old man cleaner who was cleaning the toilets. He had the ability to open a locked door in a cubicle, and he was confronted by this young fellow. The young fellow pointed the shotgun, a sawn-off shotgun, at him. Now, I think you can see my hand. You imagine my finger is around the trigger. The old man pulled the gun. Well, the effect of pulling the gun away towards him, pulled the trigger. And it blew a hole in his chest, frankly. The young fellow ran out of the pub, where he was confronted by an Alsatian dog, and he shot the dog with the other barrel of the shotgun, ran away. And 6 months later was arrested. What had happened in those 6 months? Well, when he'd gone to the pub, he had carried the gun in a wrapped up piece of brown paper. The brown paper had a Red Star stamp. I don't know if Red Star still works. What Red Star is the situation where you put a parcel on a train and it was delivered. The Red Star stamp had a date, and a detective sergeant had gone to the station with the date and said how many Red Star packages were sent on this day. There were hundreds of them. and he went to each one of those who had sent the packages. And he came to a firm that was selling rugs, showed the packaging to the owner of the firm and the date. The owner of the firm said, I sent out two packages on that day. One went to Birmingham and one went to Newcastle. The sergeant went to Birmingham to the recipient and said, did you receive a package on this date? The person, I don't remember. What did you do with it? Don't remember. Went to the Newcastle one. The Newcastle one was an elderly lady who said, oh yes, I remember that. It was a rug came in this package. It was my grandson's birthday, and I readdressed it and I sent it to my grandson. So there was the link. And I have to say, there was no clever computing, there was no DNA, there was nothing like that. They had him to rights, right? They had him to rights through the plodding, hard work of a detective sergeant. And then I congratulated the detective sergeant on his work, and I said to the young man, they have got you to rights. There's no way that you could have got this piece of paper, which the gun came in, unless you were the person who brought it there. And you've got a choice now. You complete guilty, you will get a prison sentence, which you will have to serve. It will be a long sentence, but at the end of that sentence, you probably will be mid-30s, and then you will be eligible for parole. Don't plead guilty, then you're looking at least 10 years longer before you'll be eligible for parole. And he pleaded guilty. The point of this story is more to do with the question that is asked of every criminal lawyer. How can you defend somebody that you know is guilty? How do you do it? How do you morally do that? And the lawyer's standard answer is, I'm not a judge. I'm not there to judge. It's the jury who's there to judge what happened, and it is the judge who will apply the law when the jury says what happened. And that's a lawyer's answer. It doesn't work quite like that. The truth of it is that very, very rarely do you know that somebody is guilty. You can suspect it, and you can have a very strong suspicion that the person is guilty, but it doesn't mean to say that he is guilty. And if you then are going to act for him, then it's your job to put forward his point of view. After all, against him is the whole battery, of the prosecution side. So you give a level playing field. But the prosecution has to give you their evidence. And as you get experience, you can see from their evidence whether somebody is going to be proved guilty or not. And if somebody is going to be proved to be guilty, then you tell the client. So very, very rarely do you come to a situation where you can't predict the outcome. And juries basically, in my experience, get it right. People say they should do something about this. Well, who's the they to do something about it? But when you have a jury trial, the jury is the they. And juries take it all very, very seriously. I've acted in many, many cases, and normally your client's on bail. And one of the things I say to a client is when you go to court, the most important thing is that you do not smile. You do not show you are happy, because you don't know if on the train coming to court with you is a juror. And they take it very, very seriously. And if you think it's a joke, that will act against you. So the question of how do you defend somebody who is guilty? Well, the lawyer's question is, it's not me to judge. But the real answer is, it doesn't happen that often. Because If the evidence shows there's a doubt, then the client is entitled to the doubt. You can't help him make up a story. You cannot act for him if he says, I am guilty, but I want you to get me off, right? Once somebody says he is guilty, and things are not always so clear cut. So let me tell you about, people like to hear about murder cases. And it's only a small proportion of cases, but think of the most exciting cases. But they're not always so straightforward. I was asked to act for a lady who had killed her child. It was absolutely horrific. She had killed a 2-year-old daughter. And I, at that time, my eldest daughter was 2. And looking at the photographs in the case, and the prosecution insisted on a charge of murder. And the lady, well, there's no question she wasn't in her right mind. You defend murder, but you don't necessarily defend manslaughter. You can say that there was no question that she had committed the act. But to charge murder was, or to charge manslaughter, it doesn't quite work that way. I acted in another case, so the last of the murder cases, right? A man had battered his wife to death with a pipe. He had run out of, it was a shop opposite my office. And he ran out of the office, his shop after doing it, up a railway embankment and threw himself in front of a train to commit suicide. He wasn't very good at that because all he did was break his leg. And I went to see him in the prison. He was in the prison hospital because of the broken leg. And it was one of the most frightening incidents of my life. I had gone in, it was dark, it was November, it was in the evening, and I'd been to the solicitor's visiting block in the prison. I'd never been to the prison hospital before. And somebody said to me, look, we haven't got somebody to escort you, but if you go out here, turn right, turn left, there's a door there, knock on that door, and they'll let you in to see him. I came out of them and I turned right, turned left, and was confronted by an Alsatian that it hadn't heard me. And that dog had death in its eyes, right? Fortunately, the handler had it on a very, very strong lead. But that dog was really terrified. What had happened in the case? This was a man whose wife had been beating him for years and years and years. And on the last occasion that she was beating him with a length of pipe, he took the pipe off of her and he hit her back. And he killed her. Was he guilty of murder? Well, the answer to that was he was guilty of an offence because he had lost his temper, and it wasn't just take the pipe off of her and restrain her. He then had gone overboard and had killed her. He was convicted of manslaughter. So those are the murder cases. There are not so many murder cases, but there are other incidents, funny incidents. One of the funniest incidents that ever happened in my office was I was sitting at my desk on the telephone. Right, my office was above, my room was above the reception. The phone rang, and the reception said, "I have 3 ladies here who tell me that they have inherited $1 million, and they would like some advice." So I said, "Okay, give me 5 minutes and I'll see them." And 5 minutes later, I rang down and said, "Okay, send them up." And they didn't appear. I waited, and they didn't appear. And I rang down and said to my receptionist, "Are they coming?" And she said, "Yes, but they're walking up the stairs backwards." Backwards? Anyway, they appeared, three of them, 94, 96, and 98. And I said, after they settled down, etc., they said, "Why were you walking backwards? Less strain on the heart." Well, that's interesting. Anyway, and they sat and they looked at me. And I said, "But ladies, I told you I have a problem." Said, "Oh, yes, right. Our sister has died." And I'm very sorry. Um, and they've left us $1 million. I said, "How do you know?" She said, "We've got this letter from an American lawyer." I took the letter and I looked at it. It wasn't $1 million. It was $10,000.00 That is a one and six noughts. And I thought, oh my God, they're going to die of shock when I tell them that that's not. They haven't inherited $1 million. They've inherited 10,000. So I said to them, "Ladies, I'm very sorry. You haven't inherited, $1 million. It's 10,000. Oh, thank you, Mr. Kaye. Oh, wonderful. Thank you." Well, here I'm thinking that they're going to die of shock. And I said, "Sorry, where could our sister have inherited, or got $1 million?" They were so happy. So there's an incident there of somebody losing $990,000 and being happy about it. Other criminal cases, and people again are always interested in criminal work, is I was consulted by a gentleman, Swedish gentleman from Stamford Hill, who told me that he was the governor of a school, a girls' school, and that he was being prosecuted for theft of money from the school. And he said, "I didn't do it, so it's okay." So I said, "Well, okay." I got the prosecution papers, and I went through them, and it was clear that he had withdrawn a lot of money from the school funds. So I asked him to come in, and he came in. I said, "Look, the documents here, if you go through them, show that you've taken this money out of the school." He said, "Yes, I did. It was owed to me." Sorry, I'm going to typical my phone rings. And I'm going to switch it off. Sorry. But I didn't do it, so it'd be okay. "Don't worry, Mr. Kaye." I said, "I'm not worried, but we have to prepare a defence for you." He said, "No, it's okay. I will be all right." "You can't be all right if you just leave it to the prosecutor." "No, my Rebbe told me I'd be all right." Who's your Rebbe?" He says, "Bels." I said, "Well, I cannot do this unless you help me with the defence." He said, and he's reassuring me. He said, "Don't worry, it's okay." And he refused to cooperate in his defence. So I asked around. I said, "There's something. What can I do? This man will not help me." So he says, "Well, the thing to do is get in touch with the Bels Rebbe in Yerushalayim." I said, "Well, how do I do that?" So you send him an email. And they gave me the Bels Rebbe's email. And I emailed him. The next day, as I opened the door to the office, there's the file. And we went through the papers. He said, "The Rebbe told me I've got to help you. Not I've got to help himself. He's got to help me." We went through the papers. And what was clear was that this gentleman, who was a really nice man, had supported the school over a long period of time when the school did not have any money. And he had paid the teachers from his own pocket. There came a time later when somebody had made a large donation to the school, and he repaid himself. So he wasn't stealing. But what did the books show? The books showed him taking money out. It didn't show money going in. So we employed a forensic accountant to go through the books of the school so that it could be seen that for a long period of time there was no money in the school, yet the school was operating. The only logical explanation for that was exactly what my client had said, was that he had been paying for it out of his own pocket. That the forensic accountant said that the amount he's taken out looks to be exactly what would be the cost of running the school in the time. So we ran that in court, and we looked. This was in the Luton Crown Court, and I approached it on the basis that I employed somebody who he didn't like, but was politically correct for the case. I employed a black lady, right, QC, to act for him. He wouldn't go near her. You'd hardly talk to her. But she effectively, with our forensic accountant, took the prosecution case apart. We got to a point in the case where the judge.
Yeah.
We got to a point in the case.
Yeah.
So as the lady who hasn't. Well, it doesn't matter. We got to a point in the case where the judge said to the prosecution, "Do you really want to go ahead with this?" And they dropped it. Meanwhile, in the foyer of the Luton Crown Court, there had for the previous 2 days been a bunch of Casitas gentlemen saying Tillim. And when the case was thrown out, there was dancing in the foyer of the court, which made the front page of the local newspapers of Stamford Hill Casitas gentlemen dancing in the court. I see that the time is, it's nearly 3:45. I'll tell you about one other question, or one other case, civil case. I've got enough material to do, 5 more sessions like this. Client of mine had a loan from one of the major banks, and he was being charged interest on that. And he felt that there was something wrong with the deal and asked me to go to see the bank. And I went to see the bank, fantastic office in the heart of the city. To get to their room, there was an escalator within the building. And I came into the room, there was a round table, fit for the knights of the round table. It was a large table. I came in, sat down, and 10 minutes later, 7 people from the bank came and sat down opposite me and said, "Mr. Kaye, we're here to tell you the terms that the bank is prepared to settle this." And I listened to it. And I said, "Well, that's not reasonable. My client's position is," and I didn't know another word out before they said, "We're not interested in that. We are interested in telling you what the bank's terms are. We're not interested in negotiating about it." And I said, "Well, it's not just the matter of terms, there's a law as well," to which he then repeated again, "I'm not interested in what you want to say." The arrogance was just unbelievable. At which point I took my papers, put them in my case, and I walked out. Got back to the office. When I got into the office, the phone was ringing. It was the bank. They would like to speak directly to my client without me being present. I asked my client. Phone the client. He said, "I'll see them, but they can come to me. I'm not going to them." They went to see him, laid out the same terms, and he, in not very polite terms, told them to go forth and multiply. We ended up going to court, and where this gentleman, we're talking about the chief, the head of the Chancery Division of the High Court, This gentleman came to give evidence, didn't even wear a jacket or tie. The court threw him out. We won hands down, and we made law. And it was a reported case. And in fact, a reported case means one that's reported in the press reports as making precedent law. So I have, in the last 3 years of practice, I had three cases that made law. I'm actually very proud of them all. There is, and there are so many other things. I'm sure that you've got some questions. We've got 10 minutes or so. Uh, I think Rabbi Portnoy is listening. If you unmute people, I'm prepared to take some questions. All right, Keith Gordon, thank you. Much interesting for recollections for your distinguished cousin Keith Gordon. Yes, that's a message that's come up. If there are no questions, I'll tell you another story. Okay, let me tell you then another story. This happened really a long time ago when before, uh, where was it? I think it was northern Cyprus. I had a client who was dealing with Romania, with the Ceausescu regime. And one of the biggest businesses of Romania at the time was to make textiles, which they would then put Gucci labels and things like that. So they're all knockoff stuff. This client then would take really container loads of it to on a ship, dock the ship in Italy to show that that's where the goods came from, and then would sail it to Amsterdam, where the goods were sold. And he had made millions of euros in there, but certainly equivalent of millions of dollars in profit. And one Christmas he was in Miami, and he phoned me to say that all of his partners had been arrested, um, and that he was in Miami, and from he wanted me to find out what happening. What was happening was headed by Interpol in Vienna. So he paid me to go to Vienna, where very interesting. Apparently, all lawyers in Vienna are uh, called Herr Doctor. And I landed in the airport, and there was a message which I didn't understand at first, asking for Herr Dr. Kaye. Well, Kaye is just pronouncing the E on K. K. And I met somebody, and I found out about the case. I was there. I then flew to Miami, where I saw the client, explained to him, and thought that there was no extradition for this offence at the time, and came back to England, didn't think any more of it. 8 months later, the client walked into my office. And I said, "What are you doing here?" And he said, "Well, I changed my name." I said, "What do you mean you changed your name?" He said, "Well, I went with my wife from Miami to Reno, where I got an American Reno divorce from my wife. I then had a marriage of convenience with an American lady, and I I changed my name on marriage to her name and applied for American citizenship." Now, we were talking about a very long time ago. It apparently was much easier. Got an American passport and then continued working. He was still with his wife, but had an American passport, new identity, and I heard no more of him. So, ladies and gentlemen, I have got a lot more material, but I will talk to you all again. Um, and unless there are any questions, thank you very much. We have another talk next Thursday. Perry Burns will be giving a talk on a subject to do with electricity, etc. I see Daniel Morgenstone has said thank you very much. Okay, so I'm not sure how we end this. Um, Thank you. I will. I hope you enjoyed the talk. I will see you again hopefully next week, and I will do more talks because I've got many, many more stories.